This is Bloomberg Law with June Grasso from Bloomberg Radio.
Mail-in ballots are corrupt. Mail-in ballots, you can never have a real democracy with mail-in ballots. And we, as a Republican Party, are going to do everything possible that we get rid of mail-in ballots. We're going to start with an executive order that's being written right now by the best lawyers in the country to end mail-in ballots because they're corrupt. And you know that we're the only country in the world, I believe, I may be wrong, but just about the only country in the world that uses them.
In fact, more than 30 countries, including the UK, Canada, and Australia, use mail-in voting. But President Trump has complained for years about mail-in voting leading to fraud without any evidence. And in an interview with Fox's Sean Hannity, Trump pointed as validation to comments by Vladimir Putin, Russia's authoritarian leader.
You know, Vladimir Putin said something, one of the most interesting things. He said, your election was rigged because you have mail-in voting. He said mail-in voting, every election. He said no country has mail-in voting. It's impossible to have mail-in voting and have honest elections. And he said that to me. It was very interesting because we talked about 2020. He said, you won that election by so much.
Trump says he'll sign an executive order targeting mail-in ballots and voting machines, which he also claims are, quote, highly inaccurate. He's trying to prevent Republicans from losing control of Congress during the midterms in several other ways. There's the widely publicized demand that Texas Republicans redraw their congressional map to create 5 new GOP seats. And in March, he signed an executive order, now put on hold by federal courts, that would require documented proof of citizenship to vote. My guest is constitutional law professor Rick Pildes of NYU Law School. Rick, under the Constitution, what roles do the president, Congress, and the states play in elections?
So let's start with the president, actually. So the president has no power constitutionally to dictate to the states how they conduct national elections. The Constitution gives states the power to regulate the way in which our national elections are held. And the Constitution also gives Congress the power to decide to sort of supplant the states in that role. But the president has no power constitutionally to dictate how states conduct elections.
What could Congress do? Let's say Congress agrees with President Trump. What could Congress do to change the way elections are held?
I think that begins to get us into the more significant questions, in a sense. So even if the president doesn't have the power to do this, once he puts the marker out there on this by issuing the executive order, then the question becomes, what's going to happen in the states and what's going to happen in Congress? Congress, in theory, does have the power to determine issues like the appropriate use of absentee ballots in national elections. Congress could require absentee ballots to be provided. It could determine the conditions under which they can be used. And I think in theory it probably could ban their use. There might be some constitutional challenges individual voters would bring. But fundamentally, the Supreme Court has recognized extremely broad power in Congress to regulate national elections under the Elections Clause. Now, whether Congress would actually do this, I'd say fairly skeptical about, because number one, of course, as long as we have the filibuster, the Democrats are going to oppose this and it won't get through the Senate. But number two, the Republicans have for a very long time been very much against nationalizing the election process. There will certainly be some Republicans, I would imagine, who would go along with the president. But I think there might well be pushback from within the Republican Party on going down this route at the national level. Election administrators, including in red states, are not going to be happy about a change like this because it means the election process will be more complicated for them to run, because it would increase the number of people who would turn to in-person voting. So in theory, Congress could regulate in this area, but I don't know what the politics will be about that. I think then the question is, what will happen in red states, that are run by legislators and governors who are sympathetic to the president's agenda, and will we see significant changes going on in red states about the use of absentee ballots?
And let's say Congress does pass a law like that. What would a challenge look like from the blue states?
So if Congress were to ban absentee ballots altogether, I can imagine individual voters who cannot be in the jurisdiction on Election Day or during the early voting process, if a state has early voting, who say, I just can't exercise my right to vote at all, in effect, because I just, for whatever reason, cannot be in the jurisdiction during those days. I could imagine they might bring a challenge under the federal Constitution and sort of right to vote constitutional doctrine. They would argue that this ban would impose a severe burden on their voting rights. So I suspect that would be the form the challenge would take. And I think the voters who would have the strongest case would be the voters in that category I just described, people who just physically can't be in the jurisdiction during any of the days on which voting takes place. I don't know whether they would win that constitutional challenge, but that's what I would envision.
Yeah, I mean, the military votes by mail for that reason. Also, Republicans poured tens of millions of dollars last year into convincing their voters that ballots by mail are safe, and Trump himself has voted by mail. Now, what about voting machines? Trump wants to go from voting machines to paper ballots with watermarks.
Well, I don't understand exactly what he has in mind yet about that. So we do overwhelmingly vote on paper ballots already. The question then is how those ballots are counted. And typically, that's where machines come into the picture. So if you vote on, what's called an optical scan machine, you fill in the bubbles on your ballot. You then enter the ballot into the machine that tabulates the votes. So I doubt he means, or I'm a little loath to speculate, if he means that voting should be done on a paper ballot, most of our voting already takes place that way. If he means that the vote should be somehow counted by hand rather than counted by a machine whose accuracy has been, validated, and by the way, we also do audits after the tabulation to make sure the machines are accurately counting the ballots. If he means to get rid of machines for counting the ballots, it's very hard to conceive of what that would mean and how that could possibly be done, because it would mean, hand counting millions of ballots, which would introduce huge delays in the counting process. And we know counting by hand is actually much less accurate than using the machines to count the ballots. So it's really unclear to me what he even has in mind about voting machines. I guess we need to see what the order actually ends up saying.
What's really going on here? Is it an attempt to give the Republicans an advantage in the midterms because Democrats supposedly do better with mail-in voting than Republicans? Or is it a power grab or something else?
It's a little hard for me to speculate about what exactly is going on. He's obviously had an issue about mail-in ballots for quite a while. He made a big issue of this in the run-up to the 2020 election. I think the view is that ended up hurting him in the election because many Republicans then decided not to vote by absentee ballot, and whether those people voted in other ways or not, we don't know for sure. I'm sure that this statement by him is causing consternation among other elected Republican officials who probably think it's not in their interest to abandon absentee voting. But, for whatever reason, he has a bee in his bonnet about this issue, and he lacks the power to do anything directly about it. But we'll see if Congress ends up doing anything.
Yeah, a federal judge Trump issued an executive order in March that would require proof of U.S. citizenship to vote and ban the counting of valid mail-in ballots that arrive after Election Day. And a federal judge has already blocked that order, at least temporarily. So does that indicate how other challenges might fare?
Well, I think there's little doubt that an executive order that purported to tell the states that they could not use absentee ballots would be blocked by the federal courts. Again, I'm a little hesitant to speculate, too much until we see the actual order and what the order actually entails and how it's designed and what powers it asserts. But he doesn't have the power to dictate to states that they cannot use absentee ballots or can only use them under certain conditions. So I don't have much doubt that an order that did that would be struck down, put on hold by the court.
Trump and Republicans have tried to reshape elections in other ways over the years with tougher voter ID laws, restricting access to the polls, the fights over voter rolls and the counting of ballots, and now pressuring Republican states to redraw their maps, with Texas about to do that to get 5 more Republican seats for the midterms. Does all this cause the public to have less confidence in the integrity of our elections?
I think that having a stable framework for our elections, which is what we had and took for granted for many years in the recent past, certainly helps promote confidence in the process. I think when the political parties and the candidates are continually fighting over voting policy, changing the rules in one direction or the other that they think, is in their partisan interest, I think that certainly undermines public confidence in the process. It creates a sense that the rules are being rigged by one side or the other for their own self-interested reasons. And I don't think that's, overall healthy for the democratic process.
Rick, are there any persistent problems with mail-in voting?
When we have had problems in the voting system with fraud, it has been in the absentee ballot area. It's not a huge number of cases, but we have had some just recently in New Jersey in the 2022 elections. There were criminal convictions for fraud that I think he was a city council member, was engaged in and pled guilty to. So I don't want to say there's never fraud in the absentee ballot process. It does happen occasionally, but it's very rare, and there are safeguards against it with the way ballots have to be validated and the like.
Coming up next on the Bloomberg Law Show, I'll continue this conversation with NYU law professor Rick Pildes. The Republican-controlled Texas legislature is poised to vote soon on that redistricting plan. You're listening to Bloomberg. I've been talking to constitutional law professor Rick Pildes of NYU Law School. Turning to what's become a redistricting battle, the Republican-controlled Texas legislature is poised to vote soon on that redistricting plan that resulted from President Trump asking them to get 5 more GOP seats for the midterm elections. I take it that though it's very unusual, there's no legal impediment to mid-decade redistricting.
We've had very little mid-decade redistricting in American history, certainly modern American history. The last time this happened in a way that went to the Supreme Court actually was also from Texas in the early 2000s. I actually filed an amicus brief in that case urging the court to hold that the federal Constitution precluded mid-decade redistricting. The Supreme Court didn't agree with that position, but we're in a world in which control of the House rests on such a fine margin, kind of election after election, which is a very important part to understand as a backdrop to all of this. And so it leads the political parties to fight over every single inch of terrain. And so various kinds of, norms that have been around for a while just, are breaking under that pressure, which is what's happening with the constraints against mid-decade redistricting. And the Pandora's box that opens up is not only, if a state can do it once, they could just adjust their districts every couple of years to try to maximize partisan advantage throughout the decade. And, of course, it's going to trigger, retaliatory mid-decade redistricting. And it's another example of the kind of tactics that, at the end of the day, really undermine public confidence in the legitimacy of the process. Gerrymandering is bad enough when it happens once a decade. But if we move down a path toward sort of perpetual redistricting for partisan advantage seeking, it's all the worse. So none of these things really promote the integrity of the process from the perspective of voters.
What's the argument that the Constitution prohibits mid-decade redistricting?
Well, the argument was that the Supreme Court has said that partisan gerrymandering or excessive partisan gerrymandering is unconstitutional, but that the court can't develop judicial standards that are appropriate to manage that problem. But as a prophylactic measure against partisan gerrymandering, a per se rule against mid-decade redistricting doesn't require the court to wrestle with, exactly how much gerrymandering is too much. It's a way of imposing at least some constraint on partisan gerrymandering, and that's sort of the argument. This is an area where you can do something without having to address the difficulty of coming up with standards for what a fair map is. Just a per se rule that unless a court orders mid-decade redistricting, the Constitution should limit it. But as I said, that's not the law. And even more so, the Supreme Court has said that partisan gerrymandering is not something that the federal courts can address. So that's where we are.
And the court is most likely going to address the issue of racial gerrymandering in the next term. Thanks so much for joining me, Rick. That's Professor Rick Pildes of NYU Law School. You may remember the story, or you may have even seen the viral video of the now famous D.C. resident who threw his Subway sandwich at an ICE officer, apparently after cursing about the federal takeover of the city. In addition to being fired from his job in the criminal division of the Justice Department, Sean Charles Dunn, a decorated Air Force veteran, has been charged with felony assault on a federal officer for throwing the sandwich. You can now also see a video of the rearrest of Dunn in a SWAT-style raid as more than a dozen federal agents with guns drawn converged on his apartment where he peacefully surrendered. That's because the White House has posted a professionally edited, dramatic video of the arrest entitled Nighttime Routine, Operation Make D.C. Safe Again Edition. Joining me is national security expert Bradley Moss, a partner at Mark Zaid. Brad, the White House is sending social media teams to go along with law enforcement and videotape FBI arrests. Does this violate the suspect's constitutional rights?
The Supreme Court, in about 20-something years ago, possibly 30-something years ago at this point, had addressed the idea of embedding media with law enforcement in the context of doing work. And the Supreme Court had basically overturned the policy, saying it was violative of people's First Amendment, Fifth Amendment, and Fourth Amendment protections. After all, you are presumed innocent until proven guilty, and there was no legitimate basis to have news media embedded with law enforcement for that purpose. What we're seeing here with these social media influencers embedded with the FBI or whichever federal law enforcement agency is conducting these particular raids is even greater abuse of the process, in the sense that it's not even pretending to be about news gathering or objective journalism. This is straight up political hackery. These are social media influencers. These are media players with a very explicit partisan agenda designed not to gather facts, but to push the White House's specific narrative about what is transpiring. This entire process, as far as I'm concerned, is at least unethical, if not likely also illegal.
What would be some of the possible legal challenges?
So you're almost certainly going to see at some point various pretrial motions for, pretrial publicity issues tied to the inclusion of these social media influencers being embedded and publicizing this. There's going to be various actions taken by defense attorneys claiming their clients' privacy rights and constitutional rights were violated by use of these embedded individuals. How that will play out remains to be seen. I don't think the cases necessarily are thrown out simply based off that, but it is entirely possible it will cause some problems with prosecution of these cases. And if that does start occurring, if the courts start pushing back by way of these pretrial rulings, I think you'll see a shift in the policy from most of the agencies and from the White House, if for no other reason than it'd be undercutting their ability to do what they say they're trying to do, which is to identify, arrest, and convict criminals.
Could it also become part of the evidence of the defense at trial, perhaps demonstrating, bad conduct by the arresting officers or that the defendant was being targeted in some way?
Yes, all of it would be discoverable. All of it would be potentially exculpatory information that would have to be turned over to the criminal defendants and their counsel. All of it could be brought up, not only from a factual standpoint, depending on what the various footage shows, but also simply if there's a political or vindictive prosecution pretrial motion brought. This would all be information that these defendants would be entitled to obtain and to use in their own defense, which is why normally we don't do this. You especially don't do it with these types of individuals following along in the cars, because it poses so many problems for the ultimate actual prosecution of the crimes.
And also, does it run against the Justice Department's policy to insulate criminal investigations from political influence?
Yes, but of course, as we're seeing with everything in the Trump administration, policies, norms, customs mean nothing. Those are all, the restrictions of the deep state and the weak, people who didn't really want to fight, crime and just wanted to look, politically correct. So they don't care about any of that. The entirety of these actions and the entire purpose for promoting it in this way is to push completely partisan propaganda and to utilize these institutions of the state in order to push that propaganda, not necessarily even for a particular political party, but for one person, Donald Trump.
The White House is owning it. A White House spokesman told Reuters that this is not a standard law enforcement posture because this is action directed by the president, deeming what is necessary and appropriate under the law.
Yeah, well, unfortunately for Donald Trump, he doesn't decide what the law is, at least not in our current form. We'll see what the courts ultimately decide to just completely bend the knee and succumb to him. But at least at the moment in this constitutional republic, he is not the law. The courts decide what the law is.
I mean, the FBI has allowed the media to do ride-alongs. When I was a local news reporter, I did a ride-along with police, but you were always careful to obscure the video of the suspect's face.
Correct. And there have been TV shows. You think of the infamous show Cops that's been around forever. Those shows did have some kind of media embedded within it, but there were very strict protocols and procedures. There were waivers that had to be signed by anybody whose identity was shown, anybody whose information was made public. And of course, that footage was always then had to be made available to those defendants when they went to trial. And so this is why there were always those limitations put in place, because while it makes for great TV, while it looks cool on social media with the hype music and the rah-rah, beating their chest machismo that the White House is doing, that doesn't necessarily mean it's going to be helpful when it comes to actual trial. And that's what we're waiting to see is, does this backfire from a legal standpoint by undercutting law enforcement's ability to actually prosecute successfully these criminals?
Last week, the White House posted a highly produced promotional on its X account documenting the rearrest of Sean Charles Dunn, the now former Department of Justice employee who threw a Subway sandwich at a federal agent. You have all these police, FBI agents, and federal marshals in full gear with guns drawn and carrying bulletproof shields to get this guy whose weapon was a Subway sandwich, and they converge on his apartment, and he just opens the door. And it took about 8 minutes, and it ends with a black screen showing the White House and the words, "The White House, President Donald J. Trump." I'm not sure why they would want to promote using all these federal agents to rearrest the guy who'd already been caught after he threw the sandwich.
The way they're approaching this, the hype videos they're doing, it would make, Nazi propagandists blush, because this is just gross abuse of a vital entity, an institution in government, which is law enforcement, which is necessary to the survival of any state, but it is turning it into not an arm of government, not an arm of the law and the Constitution, but an arm of a political entity and a particular political official, namely the president himself. And that is not what the Justice Department is supposed to be. That is explicitly not how this is supposed to be handled. But as far as Donald Trump is concerned, he was vindicated in 2024 with his victory, and the public is ready to let him just do whatever he wants on that front. And that's why he's doing it. He got an immunity ruling. He got everything he wanted. He overcame convictions, and he got back to the presidency. And as far as he's concerned, he's going to push this envelope as far as the law will allow him to do.
Doesn't it also erode confidence in the FBI and federal agents?
That's got to be one of the bigger concerns. I mean, so we've seen this for the last 10 years, ever since Trump came on the scene, ever since Crossfire Hurricane, the Mueller probe, all of this. There's been these bipartisan food fights over, the integrity of law enforcement. Republicans basically assume anybody in the intel community who doesn't toe the Trump line is a deep state operative out to get him. And for, people on the left, they're basically assuming everyone who's getting purged, anyone who's left, are all just toadies of Trump's propaganda who are, getting off on basically beating up everyone they want and walking around with masks and grabbing people off the street. The fundamental problem that you have that underlies every collapsing governmental institution throughout history is when people lose trust in the basic functions of the state. And the greatest threat there is from Donald Trump right now is that the public may never fully regain that trust in the FBI, in CIA, in the intelligence community at large. We've had moments in history in this country where that trust has been eroded. This is now getting to the point people are throwing sandwiches, like you said, at the cops. They're calling them Nazis. And it's because of these raw emotions tied to both sides of this where no one trusts anyone anymore. And it's becoming the point where no one can trust that anybody acts in good faith.
And talk about overcharging. The U.S. Attorney, Jeanine Pirro, is charging him with a felony, forcibly assaulting, resisting, or impeding a federal officer, which, the maximum is up to 8 years in prison. But what D.C. jury would convict him on those charges?
Yeah, it'll be interesting to see, one, if that stuff gets reduced in pretrial motions, but two, even if somehow even one aspect of this does get to a jury, whether or not they can find a jury that would convict this guy based off that kind of evidence. It's laughable right now to assume that would happen, but it's entirely plausible. It's entirely possible that people would simply look at it from a strictly legal standpoint and say, do I think this is a ridiculous case? Yes. Did his conduct meet the scope of the statutory provision? Yes. Okay. Guilty. I don't foresee that whole case going through to the end with the original charges. This is all a media spectacle right now. We're seeing U.S. Attorney Pirro having problem getting indictments from grand juries because they can see how ridiculous this is. I fully expect this to be just another case of that.
Yeah, and his lawyer says she was trying to arrange his voluntary surrender. Tell us about the problems Pirro's been having lately.
So there have been problems lately with prosecutors going to the grand juries trying to get indictments based off these various arrests, and the grand juries are refusing to indict. The old standard is you indict a ham sandwich. Apparently, you can't even indict a ham sandwich at the moment because the grand juries are seeing how preposterously stupid some of these arrests are. Look, there is a clear and explicit need for law enforcement to operate in any functioning society. There's a clear and explicit need for prosecutors to be able to prosecute cases. There's also recognition of the preposterously stupid when it comes to some of these cases, which is why objective, rational adults normally don't bring them. It makes for great TV. It makes for great outrage bait on social media. It's not how a functioning society operates.
The Justice Department is investigating whether D.C. falsified crime data. But I'm wondering about the data the White House is handing out on these arrests in D.C. because the details have been hidden.
We were speaking to the idea of people losing trust. The biggest concern coming now is that people are going to lose trust in the data. The Bureau of Labor Statistics now, their data might get suspended because there's quote unquote mistrust from the White House and its political allies because data didn't show what they wanted it to show. The data from the Justice Department and from D.C. police about crime in D.C. is now under question because it doesn't show what the president wanted to show. He wanted to portray a city in chaos, a city like the bad old days of the 80s and the early 90s in D.C. when it was the homicide capital of the world. Those days are long gone. Does D.C. have crime? Of course D.C. has crime. It's a city. You're going to have crime. The problem is Trump is stuck in that 80s, 90s mindset. That's how he's always viewed D.C. It's a very scary place to him, and he's trying to reconfigure facts and the truth to fit his narrative.
I also wanted to ask you about Tulsi Gabbard. She's beginning anew to revoke the clearances of national security officials whom President Trump, I guess in some respect, deems political enemies.
Tulsi Gabbard is on a mission to destroy the intelligence community and to basically try to rewrite history. It goes back to Trump's original grievance, the original sin, which was the Russia investigation. It doesn't matter what Mueller found. It doesn't matter the charges Mueller brought. It doesn't matter what the Mueller report said. It doesn't matter the extent to which the Durham report vindicated the Mueller report's findings in various ways. He wants to rewrite history to say that 2016 never should have been investigated, that there was never any coordination or anything with Russia that mattered to be investigated, and that's the original sin. And now he's got carte blanche, discretion from Congress as far as he's concerned, and from the Supreme Court, from the immunity ruling, to just throw out anybody who was ever tied to it. He doesn't care about the impact on national security. Tulsi Gabbard is having the time of her life just wrecking political havoc because she knows she'll never be held accountable for anything because she'll be long gone by the time the real damage shows up. She can have fun. She can be a power player. She can go on, podcasts and joke around with Megyn Kelly. She has no sense of the amount of damage she's doing here. And the firings of these people and the revocations of security clearances has nothing to do with anything other than pursuing Trump's vindictive agenda.
Well, apparently these latest ones seem to be a directive from far-right activist Laura Loomer, who posted 3 weeks ago urging dozens of officials from the CIA and national security have their clearances revoked. Her influence is really concerning.
They always said Idiocracy was, just a movie, but no, we continue to be reminded it was simply foreshadowing reality. Because the idea that Laura Loomer is having this kind of influence, not just on the ODNI, but across the federal government, all this influence on who Trump hires and fires, someone who has absolutely no qualification to being, chiming in on any of it, to say nothing of the fact that she's not even a federal employee, not even an advisor to the president in the White House, is obscene and ridiculous. But this is the reality. He loves the Laura Loomers of the world. They do his dirty work, and he can just, use power like he's a mafia don. The only damage, of course, is the damage to national security. But hey, who cares about that anymore?
Thanks for joining me, Brad. That's Brad Moss, national security expert and partner at Mark Zaid. That's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.